lawsuits in America are prevalent. 4.4% of the world's population, 80% of the world's lawyers, 96% of the world's lawsuits. We have a lot of lawyers and we like to sue. And if you haven't already, you're going to be sued. I can tell you that. The richer, the more famous, the more fulfilled, the more power that you have, you tend to be a target for lawsuits. So if you haven't already been, the chances are you will be. You can't stop yourself from getting sued. From lawsuits, from IRS, from creditors. How do you protect yourself? Well, asset protection is basically a way for you to make sure that you are not forced to give away assets that you've worked for and that you've built. Asset protection is about giving away assets and still maintaining either ownership and or control or both. The truly wealthy not just know how to build wealth, they know how to keep their assets for themselves and their children multi-generationally. So you're protecting yourself, but you're also protecting your children. There is a way for you to actually protect your children. So there's two different bodies of law, statutory and common law. Statutory law is act of Congress. It's written in stone until it's changed or by constitutional amendment, right? On the other hand, common law is the judges making an informed decision on a subject matter that becomes precedent. When I got into business, 25, 30 years ago, there were, asset protection then was, it was about hiding your identity. And essentially, you'd set up a trust, say in Delaware or in North Dakota, and then that trust would have a beneficiary in the Isle of Man because of the tax evasion laws, which don't evade taxes, my friends, but that was then. And then that trust's owners would be in the Cayman Islands. And then, the stock of the owners, with the majority owners of that stock of those owners of that corporation in the Isle of Man would be in Guernsey. And then, so it was a convoluted, and then you'd have the bank accounts in Switzerland. And then in 2010, so you had all these funky things that were happening to hide assets from creditors and the government. And then in 2010, the government came out with this thing called FATCA, Foreign Account Tax Compliance Act. One is to avoid taxes, right? Because a lot of people were hiding their assets and at the same time avoiding taxes. So they came out with this act, Foreign Account Tax Compliance Act in 2010, which basically killed a lot of those Isle of Man, Guernsey, and all those fancy tax loopholes, right? And so, but unbeknownst to people, you didn't need those fancy things. You didn't need that trust in the Isle of Man or the corporation in Guernsey or the Swiss bank accounts. You didn't need those things. Everything you need to do to protect your assets is right in front of you here in the US, and it's legal. And I'm going to show you those things today. So the best way the first, not necessarily the best, but the first thing you should do is buy as much umbrella insurance as you can afford, liability insurance. Buy as much umbrella. Umbrella insurance is just something that covers, some people have car insurance. Some people have homeowners insurance. Some people have, other types of insurance that protect their assets. Umbrella is one that covers everything, gives you an extra layer of protection. Buy as much umbrella insurance as you can afford, liability insurance. Number two, the dumbest way to lose your assets is not to change your beneficiary designation from. I had a situation where, and I told you about this in some of my social media posts before, I had a situation where a guy was married and divorced, remarried, had kids from both marriages, and he was married to his second wife for over 20 years, and he forgot to change his beneficiary designation form on his life insurance and his retirement accounts. He stayed in the same job for 30 years. So he dies, and his ex-wife, 20-year-old, well, not 20 years old age, I mean, come on, but 20-year-old, 20 years ago, now was able to claim the life insurance, millions, and his retirement account. His new wife was left out in the cold. His new kids were left out in the cold. Please change your beneficiary designation form on your life insurance policy, on your retirement accounts, on your brokerage accounts. Make sure it is the person you want to get those assets. Number 3, your will, while it doesn't necessarily protect you from creditors, could help point, after you pass, point you in the right direction, point your estate in the right direction, and also protect your kids. Don't give kids assets free and clear. Don't just turn around and give your child your house. God forbid, you remember what I said before, nice guy, daddy gave him a nice $1 million house. And before you know it, this nice girl comes over, she gets married to him. After 2.5 years, give me half of that house. The house that daddy spent and mommy spent their whole lifetime building, spending, and growing that asset to give to you. Now, she's just going to walk away with half. So create a will and specify in the will that when you pass away, your assets will go into a trust for your children. And that trust will be a trust that is irrevocable. We'll talk about trust in a little bit. Irrevocable meaning the kids can spend the money inside the trust. The kids can take all that, the house, they can sell it and all that money, but it has to stay in the trust. They can take that money and they can buy another house and start up, but it has to remain in the trust. Number 4 is something I've talked about ad nauseum. It's one of the best tax savings methods ever. It's also one of the most amazing asset protection tools, and that's called the 401k. Now, the history of 401ks, it goes back to 1973, right? The government decided, you know what, Americans, you're all very bad savers. Y'all people, you don't like to save that much. So we're going to give you an opportunity to save where you could put money away for yourself inside of a retirement account. And it's tax deductible. You don't pay any taxes today. Wow. On the income you make. So you make $1,000, you put $500 in a retirement account. You don't have to pay taxes on the $500. Hallelujah. It's also tax deferred. You don't pay taxes as it grows. So you make 10% interest on that money, $50 on that $500 you invest. You don't pay taxes on it. Hallelujah. You only pay taxes when you take it out. But it's not just tax benefits. It's protected from creditors by statute. I mentioned before that there's statutory law and there's common law. This one is statutory. In the law, in the 1973 law that created 401ks, you cannot be sued for your 401k. If you get sued because you ran into someone, or someone fell in your home, or medical malpractice, or the IRS comes after you, or you file for bankruptcy, they cannot touch your 401k. There's something very similar to 401ks that in case you are in a company where you don't have a 401k, that you can do, or if you're self-employed and you're not making a huge amount of money to be able to do what I call a defined benefit plan, I talked about it before, you can do an IRA. You can put money into an IRA every year. And your IRA, however, is not under statutory law. It's under common law. While they're very similar in behavior, tax deductible, tax deferred, they're very similar to 401ks. They're under common law, not statutory law. So they're governed by the states. In Texas, for example, we have an office in Texas. That's why I use Texas as an example. IRAs are protected from creditors. Like a 401k, they can't touch your IRA. However, in California, God bless our soul over here, it is not fully protected from creditors. Essentially, it is the judges here haven't seen it fit to create that precedent. And so with an IRA, if you have a big IRA and you get sued and you have a judgment against you, the judge will first determine how much you need to eat. This much usually is what they give you. And then the IRA, the rest of it, they take away. So the fourth thing you can do to protect your assets from creditors is set up a 401k or participate in your company's 401k. There's numerous benefits beyond taxes. Number 5, your home is protected from creditors. Now, remember back to that story I told you about statutory law and common law? This particular one falls under common law. So with common law, the rules are different state by state by state. In California, You could be sued for your home. Your home is protected up to $75,000 in equity for you and your spouse. It's $150,000. I'll give you an example. If you buy a home, it's worth, in California, homes are expensive. So you buy a home worth, say, $1 million. And you've paid off, most of your equity, and you have almost $600,000 in equity now. You have a $400,000 loan. You have $600,000 in equity. And you're married. And you get sued. And there's a judgment against you. Big judgment, God forbid. Only $150,000 of the equity in your home is protected. $450,000 of that could go to the creditors. $450,000. Now imagine that. Your home is not protected fully in California and in many other states. But in Texas and Nevada and Florida and a few other states, it is protected. So number 5 way to protect your assets, and I'll show you when I get to the issue of trusts, how to protect your home. For you my California friends and residents out there, I'll show you how to protect your home. It's through a trust. But there's certain things that have to happen first. So go buy a home. It's a good asset protection tool, asset protection technique, if you live in certain states. Number 6, a corporation. So you set up a corporation, it gives you what's called limited liability. Limited liability means you can't get sued for the debt or the liabilities of the corporation. You are protected from the debt of a corporation. Now, let me give you a real life example. Many businesses are hurting, right, because of COVID-19. There's some restaurants out there, small business owners, who are unable to pay their bills, their rent. And so sometimes you got to walk away. I can't pay the rent. I got to move into a smaller place. Problem is you got a big lease. You got a 1 or 2 year lease or 5-year lease. And the landlord says, pay me my money. If you can't pay, they can't come after you. They can't come after David Adifeso. They can go after the company, but they can't come after me. So setting up a corporation is one of the best ways to protect your assets from creditors, the creditors of the corporation. But it gets better. Again, this falls under common law. That setting up a corporation, an LLC or S corporation or C corporation, protects you from the debt or the overhang or the liability of a corporation. But who's protecting the corporation from you? Let me repeat. Limited liability protects you from the debts of the corporation. But who's protecting this poor corporation from you? You go out, you start drinking, you get into an accident, or somebody comes to your house and falls, or medical malpractice, or something happens and you get sued. They can literally take your corporation away. Except in certain states, and again, I go back to Texas, in certain states, you have this thing called a charging order. Charging order. Pretty much what the charging order is, and it's very common with LLCs. LLCs are limited liability companies. Here's what it means. If that corporation makes money, you can't, as a creditor, you can't even get the money. So I make $1 million and I have expenses worth $600,000. You can't get the money unless I pay the profits of $400,000 out to the person who's getting sued. So if I have a corporation over here that's making a lot of money, and I keep reinvesting the assets of the corporation every year into hiring new people, building new plants, expanding, and I keep using all the cash flows, you can sue me as much as you want. I can own this corporation in Texas or Nevada called an LLC, and you can't get that corporate because no cash is coming out. The only time the creditor gets any of the assets of the corporation are when you pay that profit out to the person being sued. I take money out of the corporation. So look, if I'm getting sued, why would I take money out of the corporation? I just let it keep growing, keep investing, keep growing bigger. So setting up a corporation is a great way to protect your assets from creditors. It's a really great way to protect your assets from creditors. Number 7, and probably the most widely used and the most all-encompassing, you could protect anything through this source, is called a trust. A trust or trusts are the most widely used and accepted way that wealthy people, very wealthy people, protect their assets from creditors. What is a trust? Well, very much like a corporation, the law allows you to set up a legal entity that is different from you to serve certain purposes. For a corporation, it's to run a business. For a trust, it could be any number of things. And I'll tell you all kinds of trusts now that you can use that could be very beneficial to you. But first, I want to talk about the trust that most people think about, and that's the family living trust. A family living trust is a trust that's established primarily to avoid probate. When you die, when you pass away, if you don't have a trust or other vehicle to protect your assets, a judge is the one who determines. In a process called probate, a judge is the one who determines where your assets go. So the primary purpose of having a trust is you want to take back control. So you create this legal entity that really only comes into effect when you die, but it's still a legal entity that says, when I die, I don't want a judge to determine what happens to my assets. I want 25% to go to my first son, 25% to go to my other son, 50% to go to my wife, or whatever. It also has, sometimes they'll attach a will to it, a healthcare directive, when you go to the doctor, if you have to go through, surgery or whatever, who makes that decision for you if you can't make it yourself? It has what's called a power of attorney, durable power of attorney. If you're, God forbid, incapable of making a decision, who stands in your place? Is it your wife? And so on and so forth. So it has a will, durable power of attorney, healthcare directive, and then the trust itself. The one thing the family living trust doesn't do is protect your assets from creditors while you're alive. It does when you die, because after you die, your will has to be done. The things you specify have to be done. But while you're alive, because it's what you call inter vivos, you can move your assets in and out of the trust. The term is called inter vivos. While you're alive, you can move assets. It's revocable, right? You can move assets in and out. Because of that, it doesn't protect you from creditors. So the biggest misnomer I've heard is family trust will protect me from creditors. Not that type of trust, not the trust you're thinking about. But there's a huge amount of trusts that do protect you from creditors. Here's one of the most important ones, is the one that protects your home. So you remember I mentioned before that in certain states, your home is not protected from creditors. All of your home, like in California, is not protected from creditors. Meanwhile, in Texas it is. Well, if you're in California, you've paid off your home, you have kids or nephews or nieces or a dog you want to give the home to. Look, I don't know about, benefit, but if you have beneficiaries, you can take your asset, you can take your home and put it into something called a QPRT. QPRT is the acronym for Qualified Personal Residence Trust. You're going to need a lawyer, but if you have a home that's worth $500 or $1 million or $2 million and you've paid it off, put it into a qualified personal residence trust, QPRT. You got to get a lawyer, but it is worth it, because if they ever sue you, you remember that $75,000 thing I talked about? I'm covered $75,000, she's covered $75,000, a couple, $150,000. It's unlimited. Now, there's certain things about a trust that you need to be aware of. The QPRT, you can't have a mortgage on it. And the reason why is because, you're protecting your assets from creditors. Who's the biggest creditor you have? The bank who gave you the mortgage. Why would they let you put your assets to protect that asset against them? They're not going to let you. So you have to have paid it off. And you also have to specify the beneficiary, and you have to, essentially after a certain number of years, the asset goes into to the beneficiary. And so they own it. And so you're basically renting the property, but it doesn't work that way exactly. That's just the technical details. But what I want you to know is there's a way for you to protect your home through a trust. It's called a Qualified Personal Residence Trust. You can Google it, QPRT. The second way, by the way, you can use a trust to protect anything. The second type of trust, which is most common, is called a life insurance trust, an irrevocable life insurance trust, right? I mean, think about it. You have all these big dollars in a life insurance policy. You have a $500,000 policy, you have $1 million policy, you have a $2 million policy, and, something happens to you, you want that inside of a trust and you want it to be protected. So your beneficiary, now you can specify on the beneficiary designation form who gets it, but a trust is more streamlined because if you do it on your beneficiary designation form of the life insurance policy, it is going to go directly to your children. God forbid something happens to you when your kids are minors. Here's a 16-year-old who's going to inherit $2.5 million. Yikes. What are you doing to your 16-year-old? You want to put it inside of a trust, that life insurance policy. And the trust, remember what I said about wills? That trust specifies that that money goes into an irrevocable trust for your 16-year-old. So he can't just take the money out and spend it. And you have to have a guardian and so on and so forth. There's ways where you can create your own annuity. It's called a Grantor retained annuity trust. There's where you can create any number of things for yourself. There's so many different strategies, but a trust is one of the best ways to protect your assets from creditors. Now, we're almost done. You want to be careful about trusts when you set them up. The reason why is a trust has two entities attached. One is the donor or the grantor, the person putting the money in, and the second is called the beneficiary. When you take your assets as a donor or grantor, and you put the money into a trust that not the revocable one like I talked about, the family name trust. This one is an irrevocable trust. All these trusts I'm talking about, they're all irrevocable. You can't change the terms. So you put all that money in there. What happens if your beneficiary, after a while, he knows you can't change the trust, and he's like, yo, Dad, I'm 18 years old. I know I got this trust in here. I want to drop out of school. I want to go live in Bel Air. I want to buy a nice house over there. I want to buy a car. I want to start living a good life. Well, what are you going to do? He owns that asset because you put it in the trust in his name, and it's irrevocable. A trust also has a third person, a third entity called a trustee. The trustee, so there's the donor, the grantor, this person put money in. There's the beneficiary, the person who is going to inherit the money. And then there's the trustee of the trust. The trustee is the one who controls the trust. So if you're the grantor putting money in, and you're the trustee who controls it, guess what? When that young son comes to you at 18 years old, and he tells you he wants I want to go live in Bel Air, I want to buy a nice house, I want to do all these things, you're going to look at him and you say, I control the trust, Junior, and you ain't getting nada. Not till you graduate from college, go to medical school or law school or accounting school or nursing school or go be a teacher or go or professor, go into a career, start working, do something good about yourself. Then maybe I'll help you. And after I die, you inherit the assets.